Hello everyone and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode, we take a cursory look at the LAC's recent decision in Shaven Gibson Packaging versus Amito and others, following the dismissal of 160 workers in 2018 for various forms of misconduct during a protected strike, including violence and intimidation, derivative misconduct, and persistently breaching a demarcated picketing area. 126 of the employees challenged their dismissal, and the Labour Court found that only 18 of the dismissals were substantively fair based on the evidence of egregious conduct, including intimidation and carrying of weapons during the strike. The Labour Court rejected the derivative misconduct charge and found that the sanction of dismissal for the breach of picketing rules was unjustified and ordered the reinstatement of the remaining employees. The employer appealed to the LAC against the decision that the dismissals were substantively unfair. The reinstated employees consisted of two groups. The first was a group of 36 employees, the SG2 list, who could not be identified from the evidence, and the LAC judges agreed with the Labour Court on the reinstatement of these employees. The second group consisted of 72 employees, the SG4 list, who could be identified from the evidence, such as photographs and video recordings, as having breached the picketing rules and court order regarding the demarcated area. And based on this evidence, the LAC majority decision found the dismissals were substantively fair, as the employees had picketed outside of the demarcated area in flagrant disregard of the picketing rules and in a manner that was tantamount to gross insubordination. The minority judgment differed on the seriousness of the misconduct, and noting the fundamental right to peaceful assembly, agreed with the reinstatement, but would have varied the Labour Court judgment to include a final written warning. In today's episode, we discuss the limits of protected strike action, the rights of the employer in terms of workplace rules, and the concept of intolerability as a consideration in a disciplinary context and in determining whether dismissal is an appropriate sanction.
Aisha, welcome back to another episode 15. How are you today?
I'm good, Debbie. There's a lot going on in June. I think it's going to be a busy month for both of us, but I'm looking forward to it. I think there's a lot of exciting developments happening within the labour space. How are you doing?
Aisha, I'm fine, thank you. Yes, agree. There's a lot going on in the month of June. And I'm looking forward to today's discussion in particular, a case in which you were cited and an article which you co-authored was cited. So let's dive right into the case. What are your initial thoughts, Aisha?
It's a great honor and I'm very excited about being cited. But just to give you some initial thoughts on the case, I think this judgment is significant. Firstly, for its stance on the rule of law during protected strikes. And, while the right to strike is constitutionally entrenched, and it's also within Section 213 of the LRA, I think this case in particular illustrates what happens when strike action can become unlawful conduct and is in defiance of court orders. I mean, even though the strike was protected, the conduct of the workers, specifically their refusal to adhere to the demarcated picketing boundaries after being expressly told to, became that focus. And I think my initial impression is that the Labour Appeal Court was clearly intent on reinforcing the principle that even protected industrial action must take place within the bounds of legality and discipline. And I think that's a strong signal to employees, to unions that, strike-related misconduct is not going to be tolerated, particularly when it can escalate to violence or intimidation.
And Aisha, do you think that the decision reflects the current state of the law? And, do you agree with the LAC decision? Are there any aspects that you don't agree with?
I would say yes, it reflects developments in our labour jurisprudence, particularly if we're looking at the post-Dunlop era, where there's an emphasis on discipline and individual accountability during strikes. And Dunlop wasn't mentioned in this case, but I think there is that logic that carries through, that the court actually emphasizes that discipline, defiance, and breach of legal norms as justification for dismissal, even in the context of a peaceful protest. And I think South African labour law has consistently drawn a line between the protection of strike action and the consequences of misconduct committed during that action. Like I said before, if we look at, the right to strike is fundamentally protected within Section 23 of the Constitution. And if we look at Section 2 and 3 of the Labour Relations Act, the LRA, they both speak to the right to strike. So I think the Labour Appeal Court reinforced that an employer is entitled to act, especially when a strike turns violent or when employees ignore court interdicts. And that said, I do have some reservations about the Labour Appeal Court decision, particularly to uphold the dismissal of the group of identified employees that picketed outside of the demarcated area. And I understand the court's reasoning. I just think maybe it gives a bit too much weight to legal order at the expense of meaningful strike action. The breach, in my opinion, was peaceful in that there were no acts of violence or intimidation, but more so that there were ongoing disputes about this demarcated area. And I think for that reason, I would say that I agree I find myself agreeing more with the dissenting judgment, particularly on the SG4 workers, which is more aligned with, I think, a purposive reading of the Constitution. And it recognizes that confrontation and disorder can be part of democratic protest without necessarily crossing into that threshold into dismissible misconduct.
Yes, Aisha, it's interesting to see how the majority decision and the minority decision in the Labour Appeal Court differ on the extent of the seriousness of the employees who were on strike, their misconduct. And for the majority, they accepted that this was serious misconduct, that there was a willful failure to obey the order and the picketing rules that had been put in place. And noting that obedience to court orders are a foundational feature of a state based on the rule of law. So failure, to do so is an aggravating feature of the misconduct. And that the breach was not of a technical nature or one that could be described as minimal or inconsequential. It is about assessing the disobedience to these demarcation rules as being flagrant and protracted. The trade union deliberately feigning confusion. On the other hand, the minority decision takes a very different approach. Agrees with the majority decision that there was a breach. But disagrees that the breach was of such gravity or magnitude and seriousness that it justified the imposition of dismissal. And rather, the minority decision takes a position that, even accepting that the SG4 employees showed no remorse, but still felt that this didn't lead to the conclusion that dismissal was warranted, and then goes on to apply the principle of progressive discipline place and a graduated approach to misconduct, so that, corrective action rather than dismissal should be taken, and therefore agreed that the dismissal of the employees was not fair, and they agreed with the Labour Court. So I think it's very interesting to see those two different approaches, and I think the case highlights the tension between the right to strike and the obligation to comply with reasonable workplace rules, and in this case backed by a court order. In your view, how do you feel the Labour Appeal Court navigated this, particularly when these picketing rules and court orders were so deliberately defied?
I 100% agree with you, Debbie. And I think they did so firstly by framing the right to strike as fundamental, but not absolute, especially when it's exercised in a manner that infringes on the rights of others or undermines the legal process in any way. So I think by relying, if we look at the judgment, they relied on video and photographic evidence, and they accepted the employer's claim of intolerability. I think the LAC justified the dismissals without insisting on pinpointing to each worker's individual conduct. And in doing so, I think that this judgment actually showed that deliberate defiance of court orders during a strike can justify firm consequences, even if it's in a collective context. And I think this is also why I agree that the dissenting judgment reminds us that picketing is not always so tidy, and defiance, especially when peaceful, shouldn't be treated the same as violence or sabotage. What are your thoughts on this, Debbie?
Yes, Aisha, I tend to agree with you. I think the position taken by the majority decision is somewhat harsh. Particularly in the context of a vibrant and robust collective action space that we have in South Africa, and by maintaining a strict observance of order when there's been a relatively minor breach, it closes the space for genuine dialogue between the parties, and so the approach which sees progressive discipline as being preferable to dismissal opens up some space at least for dialogue. But there's been another aspect of this case, and it is dealt with in the judgment, looks at the lapse of time. The strike that led to this court proceedings was in 2018. That's pre-COVID. A lot has happened since then. So to have a reinstatement order and to be trying to rectify perhaps what was an unfair dismissal at the time, more than 5, 6, 7 years later, when a lot has transpired, it seems tricky.
You're listening to the Labour Justice Barometer, and we'll be right back.
Aisha, coming back to the point that you made about the role of intolerability, that was central to the article which you co-authored with Prof. Rochelle Leroux that was cited by the decision. And it talks about the shades of intolerability in the workplace, which the court relied on in this case and cited. Tell us a bit more about the concept of intolerability and whether you think it was appropriately applied in this case.
So I think the court actually used the concept of intolerability both substantively and, in my opinion, also symbolically. In our article, we argue that intolerability is not a rigid or uniform threshold, but instead it should actually be viewed as a functional assessment of whether this relationship between the employer and employee actually remains viable, particularly when viewed through the lens of operational risk or the breakdown of trust and indicators like repeated misconduct or systemic breakdowns in discipline. Now, I would say that the LAC took this approach seriously. I don't think that it did not reduce intolerability to a mere claim of employers' displeasure. Instead, it actually relied, or the judgment actually relied on what we, through our own imagination in the article, called objective extras, which was, in this case, was photographic evidence, video footage, the clear defiance of a labor court interdict to support that finding that the employee's conduct had actually rendered the continued employment untenable, intolerable. And I think these align with the examples we actually identified in the article as well. I would also say that the court went beyond subjective views and required a factual foundation for intolerability. So I think this is actually consistent with our argument that intolerability cannot rest on the employer's say-so alone. I think it must be shown to undermine the functionality of the employment relationship in a meaningful way. So I would definitely support the cautious use of intolerability and not sidestep individual assessments in particular. In this case, the application was nuanced, and I think it was consistent with the principles that we had actually set out in our article.
That's a good development, Aisha. Certainly to move away from a subjective say-so and the idea of individual assessments. So you know that we always end our conversations around looking at the Labour Justice Barometer: green for progressive, orange for mixed, red for problematic. In your opinion, Aisha, where would you place this decision?
I think it would be orange, a mixed bag. I think on the one hand, the Labour Appeal Court was correct to insist that even during protected strikes, the rule of law must prevail. And when court orders are defied and violence occurs, the strike ceases to operate within the bounds of lawful collective action. But I do think in this case, I would tend to lean, like I said earlier, towards the minority.
Aisha, yeah, I would err on the side of suggesting that the outcome itself, I mean, again, in terms of labour justice, I have issues with the lapse of time, but that, of course, shouldn't influence my thoughts or our thoughts on the outcome of the case itself. I think it's a good, well-reasoned judgment. It gives us a lot of insights into this evolving area of law and how we should deal with misconduct that occurs during strike action. So the judgment itself, I think, is a very useful contribution to the jurisprudence. Again, to see real labour justice, I think, would have been helpful to see, genuine dialogue and engagement already at the stage of, when the strike action happened. That might have been difficult because obviously strike action involves a heated exchange. But the fact that this matter has progressed, through to CCMA, Labour Court, Labour Appeal Court, means that the parties haven't really been able to engage in a mature, genuine, good faith way to resolve this. And so, again, at an individual level, labour justice requires that disputes get resolved in a speedy way, and so to see decisions like this 7-8 years after the strike action is unfortunate. But for the judgment itself, I would give it a green. I tend to agree with you that I may lean towards the minority decision, but also, and I recognise in the judgment, that a reinstatement requires a reflection at the time.
So can we agree that it's between the orange and the green?
That's
maybe.
Yeah.
We can compromise on that. I think it's between the orange and the green on our barometer scale. But I think that's all we have time for today. So thank you so much, Debbie, for the discussion today.
Thanks so much, Aisha, and well done again on getting cited in the judgment. And as always, we'll leave the link to the case, to Aisha's article and other relevant information on today's discussion in the description. Aisha, I'll see you next time.
This podcast is not intended to constitute legal advice.